Something unique and exciting for me happened on the way to bail reform last year. We held up bail reform SB 10 in the other House for a number of reasons, but in principal part because at the time the Chief Justice of the California Supreme Court, who is nothing less than extraordinary, was in the process of putting together a pretrial detention reform work group report, which I have in my hands. It includes a group of judges from Ventura County and Santa Barbara and San Diego and Napa and Merced and Santa Cruz and Alameda, Santa Clara, all across the state, none of whom were agreed when they started this process. But what this report included, not only did I love what its conclusions were with respect to bail reform, but it did what blew me away in discussing the nature of the industry, which is the subject of this measure before you today. And I'm going to read a couple of excerpts out of that report because I think that nothing better makes the point and the need for this bill than this bipartisan, cross-reference, cross-section working group. They talked about some unscrupulous bail agents apprehend arrestees with the intent to extort premium payments, page 42. Recent complaints and enforcement actions include recipe of stolen property, contraband in lieu of connected premiums, bribery and money laundering, gang conspiracy and/or criminal enterprise, kidnapping and false imprisonment for purposes of extortion, perjury and filing of false documents, unlicensed activity, illegal solicitation, use of jail inmates and jail staff as recruiters for bail transactions, theft or embezzlement of collateral or premiums, creation of fake bail bonds, website misrepresentation and misdirection, dishonest advertising, abuse of unmonitored attorney-client jail visiting rooms. Page 42. That was not hyperbole written by an advocate. This was the language of a number of judges throughout the state talking about the state of the bail industry, the surety industry. It goes on, just a couple of more points. Beyond basic licensing information, relative little statewide data are available on the bail industry's operation in California, page 36. Bail agents, bail agencies, and sureties are not required to collect or report data on who co-signs or repays bail loans through the companies, though the companies are acting as lenders when they arrange for installment payments for fees. Anecdotal data on the impact of criminal justice fines and the fees show that most of these fees are paid by women who are posting bail on behalf of family members. In some instances, a woman may be paying to secure the release of an abusive spouse or partner. Page 36. It goes on. The argument by the industry on the other side says that one of the reports I talked about at UCLA is not peer-reviewed. I would suggest that this distinguished group of judges put together by the Chief Justice is about as good of a peer review as you can get. The bottom line is there's a delta between the body of law that we have been working in our government for many years on consumer protection and the body of law by which bail agents operate. We have situations in one instance where a company has not paid out a claim in 17 years. I suggest for anybody running for insurance commissioner, that's a pretty good idea in the sense it's like having a fire insurance company that only insures concrete houses. It is out of control. What they charge, the rational relationship between the risk, and the nature and behavior when you compare the kinds of jurisprudential thinking that we have engaged in to protect consumers in bank loans, car loans, lemon laws, example after example, and all of a sudden, the industry says, well, this is not insurance. We have a different label for this. We call this a surety. So guess what we get to do? We don't have to follow any of the rules. So all we're asking in this bill is, given the evidence, given the facts, given the history, let's take a look. Let's gather the data. Let's begin the process to start scrubbing this industry and figuring out how it operates. Now, we all know that, I'm doing everything I can with respect to reform in a broader sense. But in the near term, this is an appropriate question that needs to be raised. We are simply asking for authentication, accountability, putting stuff on websites. The UCLA study came out, looked at 400 contracts, only 15 were on websites. These contracts are written under duress. We have rescission provisions in the real estate world after 3 days. This is somebody sitting in jail. It's a relative of yours. You're sweating bullets. What do? You sign anything. Who reads those adhesion contracts? And what are the consequences of it? We are trying to bring the bail industry into modern times, into appropriate consumer protection, where they can, if they continue to exist, they will exist appropriately in a transparent manner and treat people fairly. I ask for your support of this important measure.